People v. Angela V.V.
Good afternoon. May it please the court. I would like to reserve 3 minutes for rebuttal.
Yes.
Thank you, Your Honor.
What do you think the standard is?
I'm sorry?
What do you think the standard is?
I'm sorry.
The standard of review?
The standard of review, that's a good question. And one thing that hampers us is that the appellate division decision is not a model of clarity. It's not really, it seems to me that they found that my client's evidence was legally insufficient and she was incredible as a matter of law. If that's the case.
But in your view, what should be the standard? Is it your view that that is the correct standard?
Well, if the
measure of
appellate division
sufficiency?
is saying the evidence was legally insufficient, then yeah, that's the standard. If it's saying weight of the evidence in either case, the question is, are they relying on non-existent facts, which I believe they are? And if they're not reversed, you know, what does that say about the burden of proof that domestic violence survivors will now have to meet if they're seeking relief under DVSJA?
So could you give us an example, right in front of you, could you give us an example of a non-existent fact that the appellate division relied on?
Frankly, I don't even know where to begin, but I'll
Just one. You can bring me
One?
Just one.
Okay, let's talk about Dr. Lesswing's report.
It exists.
Sorry?
The report exists.
He spent 20 hours
Yeah.
with my client. He did psychological testing. He spoke with collateral sources, including people who testified in the hearing, and other people, among them the brother of the decedent, who talked at length about the decedent's violent disposition. And he read my client's statements to the police shortly after her arrest. He considered all of this. He made a determination whether she was feigning or malingering. He said she was not. Psychologists are trained to
So
make
is that a
those determinations.
credibility?
I'm sorry?
Is that a credibility determination?
I don't think, well, here's the problem. The trial judge in the appellate division is saying, well, he didn't have sufficient data because he was relying almost entirely on the client, which is not true. There's no facts in the record supporting that. And that's legal error. You can't make a decision based on non-existent facts.
What's not true? If he's saying almost entirely, not saying only relying?
Well, that was what they said, almost entirely.
Right.
And
so
that's not true.
Well, that's your opinion of that reading of the report, no?
Well, don't forget,
I won't.
in any psychological evaluation, who's the primary source of information? The subject of the evaluation. That's not unusual.
Right, but they
And
don't
when-
have to accept that. I mean, because the doctor interviews this defendant and other people, the court isn't bound by those conclusions, right?
Not automatically, but there was no contradictory
When you
opinion.
say not automatically, that presupposes that there is a credibility determination. And
Well-
just because someone is an expert, you don't have to accept them. You
No,
consider.
But when there's no contradictory evidence, and when you're mischaracterizing the report, and when the
They
people
want-
didn't even cross-examine,
They observed the defendant testify. They can make their own credibility determinations.
yeah, but here's the problem.
Do the people
way
have
it was
to call
done,
their own
They're
expert?
appointing them, judges are appointing themselves psychology experts. There was-
But oftentimes, there are criminal defendants are tried. They don't offer evidence, but there are credibility findings that are made as to even the people's evidence. Both sides don't always have to offer evidence for a determination
No.
to be made as to whether the person who had the burden offered evidence that should be accepted or that it lacks credibility.
No, I'm not saying that. But
Okay.
what I'm saying is, don't mischaracterize the facts in the record. And that's what the lower courts
Okay,
did.
let's say the report says only, or the expert says, my conclusion is based on interviews with this individual. That's all I'm basing this on. Can then the appellate division disagree with the ultimate conclusion?
It depends. You know.
What does it depend on?
Well, it depends on the quality of the report, whether the psychologist follows established protocols, and there was no indication in this case that Dr. Lesswing failed to follow any established protocol.
But in my hypothetical, doesn't it boil down to the expert is basing their conclusion on what information they've received from a particular individual, and the court may feel that that individual is not credible?
Well, that ties in with another issue, which is, my client's credibility. And don't forget, what Dr. Lesswing said was trauma affects memory, and that's why the client did not give a completely consistent account of the offense over time.
But is it not is it not a requirement that there be a finding of facts? So who makes that determination as to accept or reject?
Well, that's made by the trial court, but
So the trial court does have the right, if it
Certainly.
if it feels or finds that it's not credible, to reject. Just because something's offered, the court doesn't have to accept it, correct?
Of course.
Okay.
But consider this. The trial court in decision said that the corroborating witnesses were, quote-unquote, not incredible, which is just a backhanded way of admitting that they were credible. So if the corroborating witnesses are credible and their testimony demonstrates that my client was a domestic violence victim, then how do you find, well, she's not a domestic violence victim? It makes no sense. It's having it both ways.
Counsel, can you connect any of this to an articulable legal error? Because it sounds to me anyway that you're making a lot of cogent arguments for why we should credit the psychologist report more than the appellate division did or more than the trial court did. But what's the legal error here?
No, I'm not asking you to make your own factual
Because
determinations.
you know we can't.
What I'm asking you to do is find legal error because the lower courts did not base their decisions on facts, because the facts did not support the findings that were made as a matter of law.
So there's no record support for the credibility determinations made by the courts below. Is that
Well,
it?
if you look at the amicus brief by Drs. Goodman and Bagaran, they're telling us that my client's, different presentations on different occasions is actually a sign of truthfulness, because what happens when a domestic violence victim finally lashes out at the abuser is they enter a dissociative state, and later on, the memory gets clouded because trauma affects memory. This is all established by science, and
So couldn't
Yeah,
couldn't
I'm sorry.
couldn't the trial judge take that submission and, credit it as far as it goes, but still make a different determination with respect to, the facts that are actually before?
well, but if there are facts in the record supporting it, yeah, but I'm arguing there aren't facts in the record that.
So that goes to Judge Canataro's formulation, I think, of the argument, which is, the argument, I take it as, there are no facts in the record that could support the trial court's credibility determination, in your view.
That is what I'm arguing. If look at it this way. If she had told the exact same account over a period of years, every detail exactly the same, I think any court would say, that's not credible, that's rehearsed.
But the
So
fact
she's
that there's-
damned if she does and damned if she doesn't.
The fact that there's an amicus brief or an expert report can't be dispositive of those
No, but it
credibility
doesn't.
findings. They might inform those
Yes.
findings.
And which brings me to another point. The archaic notions of behavior of domestic violence victims that permeate the trial court's decision and the appellate division's
What
decision.
about the nexus between the abuse and the homicide? Was that provided to the court?
Well, I think that should be obvious. And Dr. Lesswing, even though he didn't phrase it that way, I think the clear import of his report is it was an outgrowth of the domestic violence.
What does that mean? How's the court to make that determination if it's not
Based on the evidence.
phrased?
Based on the evidence.
The court
And-
actually contrasted his report in this case with the one he gave in Brenda, right?
I'm sorry?
The court contrasted his report in this case with the one that he gave in Brenda WW and said in that case, he actually connected the two, and in this case, he didn't, and they took something from that.
Well, interesting enough, in this case, Dr. Lesswing generated his report before the DVSJA even existed. So how do you fault someone from not phrasing his report in, along the lines of a statute that doesn't even exist?
But that was true in the prior case.
I'm sorry?
But that was true in the prior case.
All right, maybe so, but still, you can't just rely on the fact that he didn't explicitly say that. It's clear from his report that that's his conclusion. And it's clear from the evidence from the other corroborating witnesses that that's.
So let me turn you briefly to the third prong, right, which is whether it's harsh, the sentence is harsh.
Yeah, well,
The
interesting.
appellate division concluded it was not, the majority, correct?
I'm sorry?
The appellate division concluded, there's a separate area in the appellate division decision that says, the majority decision, that says we find this sentence is not harsh,
Yeah.
right? So is that done under their interest of justice jurisdiction? And if so, is that reviewable by us?
Well, here's a couple points I want to make on that. First of all, the trial court never reached that factor. So there's there might be a People v. LaFontaine question here. But even so, that factor is necessarily informed by the first two factors, because nature and circumstances of the offense. Well, Senator Persaud said during debate on the bill, and he was the chief sponsor in the Senate, that you have to take into account the circumstances in which the defendant was living at the time of the offense. So I don't think you can review that factor in isolation.
But the question is whether we have the power to review that prong.
Well, you have the power to review whether, the evidence was legally sufficient.
Even on an interest of justice determination.
Well, no, this court doesn't have interest of justice jurisdiction.
I understand that. But if the appellate division has made a determination based on its interest of justice jurisdiction and has done that based on a misreading of the factual record, can we review that?
I think you can. I think it's legal error if there are no facts in the record supporting that decision. So I think this court can review it to that extent. I'm not saying this court can say, we disagree with the appellate division and we're going to grant sentencing leniency to this defendant, but it can certainly remand the case for further fact-finding. So
Thank
that's
you.
where, I'd like to reserve, if I have any time left, for rebuttal. Thank you.
Good afternoon, and may it please the court. My name is Alex Stanzak. I'm an assistant district attorney for the Franklin County District Attorney's Office. I represent respondent. The court here must determine the appropriate standard of proof at the trial and appellate levels. I think that's a question that was rapid fire asked to my opponent.
What's your
here.
answer?
I'll give you my opinion.
Standard of proof or standard of review?
I'm sorry, I did misspeak. It is the standard of review. I apologize, Your Honor. So my argument is that it is an abuse of discretion standard. I understand that in my brief, I did argue it was light most favorable to, I argued, the people as the non-moving party. I understand that was the main point of contention in our briefs. But I think that the source of me coming before the court and arguing now that it's an abuse of discretion is based on the legislative history. I think that a review of the People versus Adimondo case shows that a large part of the question answer dictating the legislative history underpinning the DVSJA deferred to the court's discretion and the court's.
I took that back and forth, and I haven't read it in a while, but to be at the end of the factor test, the court still has discretion to say yes or no. So even if you meet these three prongs and you get through that litany with and or not and, at the end, you may, the sentencing judge, may instead impose a sentence in according with the statute. So I thought the discretion they were concerned about in the history was that discretion. So that even at the end of the initial analysis, the court, sentencing court retained discretion at that level to say yes or no. Doesn't really speak, as far as I can tell, to what the appellate review of that decision would be.
I understand. And I understand that reading, and I think that's a fair reading. But then, if not relying on the legislative history and the back and forth between the parties, I would rely on the standard that's been long used for CPL 440 hearings, as well as suppression hearings as it relates to evidentiary issues at the trial level, which I believe those are abuse of discretion standards as well. So I think that there is a good basis for me coming before the court and modifying what I relied upon in my...
What's analogous between what the statute requires here and those hearings that you're saying, the same standard that applies there should apply here?
I don't think the statute requires anything, and that's why I think we're here, is
Let's start with the first part, right? The first prong. It requires a finding that indeed the individual is a victim of domestic violence, correct?
Yes.
Is that not a
yes.
fact finding?
It is a fact finding,
Okay.
yes. So I apologize, I misunderstood Your Honor's question. I thought you implied that the standard review was written into the statute as it is.
Oh, if it was, we'd be in a different place.
We would not be here. Yeah.
Well, maybe we'd be here.
I do think that there is a fact finding that has to go on as it relates to the first two prongs, and then I
Okay,
think,
so when the appellate division then gets whatever finding of fact has gone on, whatever conclusion has gone on in the trial court or the resentencing court based on that first prong, what's the standard of review?
I would argue the abuse of discretion. If not the abuse of discretion, then I would alternatively argue, I know that the case before me, the court was inquiring about interests of justice. I didn't brief that, but the alternative that we have here, which both of the parties argued, is that it should be in the light most favorable to the non-movement. Here, I argue that...
So ordinarily with a fact finding, wouldn't the appellate division, we started with this in the prior case, wouldn't it ordinarily have its own fact finding power and it can replace its judgment about the facts?
I would agree if there are record facts that require the appellate division to substitute their judgment.
That require, or that, I mean, why is it required?
That
Can't they just look at the record and say, here's what the facts are, we view them differently. We weigh them differently, we reach a different result. Isn't that the ordinary fact-finding power of the appellate division?
Yes.
So is there something about this statute that displaces that as regards prongs 1 or 2?
I don't believe it's written into the statute.
Or even implicit in its structure or its legislative history or anything you can point to that would move us away from the normal power of the appellate division?
I mean, the DVSJA is written differently than ordinary 440s. One of the factual
You were just arguing it was the same as the 440.
But, I mean, insofar as in CPL 440s, there's no inherent right to appeal, whereas it's written into the DVSJA that you do have an inherent right to
And
appeal.
one would anticipate that if it was not the usual standard of review, if I can say that without too much controversy here, that they would have said so.
That the legislative...
Yes. Yes.
I can't speak for them, but the way that it is
Well, it's a
drafted...
legal matter. We're trying to figure out what standard applies to the appellate division's determination on the appeal regarding the application of this statute.
Correct, yes.
Counsel, can I ask you, now that you've conceded that at least 2 of those prongs do constitute fact-finding at the trial level, what is the standard of proof at the trial level for those 2 prongs? Because to my mind, that may actually impact the standard of review.
Yes, so it's a preponderance of the evidence review. So there has to be enough
Preponderance
evidence.
of the evidence review, over here, review or standard of
Standard.
proof at the
Standard.
trial level? Okay.
Standard, yes. Again, I misspoke, I apologize, Judge. So that requires enough evidence to produce a reasonable belief in the truth of the matter asserted.
That's the same standard they use for most non-criminal proceedings at the trial level.
I would agree with that.
Right. So,
Yes.
and that might suggest to me that then the same review standard would apply at the appellate division as would apply in the myriad other places where preponderance of the evidence is the standard below. But that you seem to say that's not the case, that it's more, interest of justice? Is that what you said?
Abuse of discretion.
I'm sorry.
Yes.
Abusive discretion.
Abusive discretion, if not abusive discretion, that the court
And
has to.
in the
look-
light most favorable to the non-moving party.
Which I say is me. So
And that's that's sort of atypical. What is it in the statute that leads you to that?
I think it's atypical as it relates to civil cases, but I think that's par for the course as it relates to criminal cases. And actually, in my brief, I look at State v. Kenneth II, which is a SOMTA adjudication, which I think is relatively similar. It's a civil proceeding that follows.
Preponderance of the evidence standard there?
I believe so.
Burden, excuse me, not standard.
I apologize for confusing the court. But yeah, I believe it's the same burden. And the court in that case utilized the light most favorable to the non-moving party, which in that proceeding, even though it was a civil proceeding, it was the light most favorable to the people. So I just juxtapose that to my opponent's position. He utilized a use of force civil case, or I apologize, it's a malicious prosecution case that's based on a use of force, where he cites a decision by this court where the standard is a review of the case and the evidence in the light most favorable to the plaintiff. But as I pointed out in my response,
And then the appellate division does what?
in the
The
appellate,
appellate division then does what? Does fact-finding?
the
Through
appellate,
this lens of, you have to look at all these facts as favorably and all the inferences as favorably as possible to the non-movement? Is that your point?
that is my point, yes, yes.
So they're
And-
still doing fact-finding?
Yes. I thought I already conceded that, yes. I believe that the appellate division can do a fact-finding. I do believe that it's in the light most favorable to the non-moving party. I argue that the non-moving party is the people in relation to this
Doesn't
case.
that standard just equate to legal sufficiency?
Yes.
Okay.
So that was what was proposed by my opponent. I responded to it, but that's why I again come to you and say, if not the standard that I argued in my brief, I would also argue abuse of discretion as the court considered in the case before mine. So I think that the court was talking to my opponent, and I wanted to take some time to address this relating to the credibility analysis that was conducted at the trial court, and I can also address this as it relates to the credibility analysis that was conducted at the appellate division. And my opponent spoke a lot about Dr. Leswing's report. I think it is dangerous to delegate the credibility determination of a defendant to an expert witness. I think that a credibility determination is the sole purview of the finder of fact and law, which in this case is the judge. I think that the judges who have sat on this case, both the trial level judge as well as the third department justices, are fully familiar with how to evaluate credibility of an individual who is before them. There is a criminal jury instruction that outlines how to analyze an individual's credibility.
What do you say about the fact that the defendant says, well, there was nothing to rebut that offer of proof?
Dr. Leswing's offer of proof?
Yes.
I don't think that a DVSJA hearing is intended to be a battle of the experts. I don't think that there's
Could the people have offered an expert?
in Angela Vivi?
Yes.
Okay.
No, I'm asking, could they have? You said
Could
you
they
didn't
have?
expect
Yeah.
it to be.
No, I don't think it's necessary. And I think it's actually an abuse of discretion for the court to defer to an expert on matters of credibility. I think that determinations of credibility are the sole purview of the finder of fact.
Okay.
I think that, and that would be my position, is that there doesn't need to be an expert witness or dueling experts, so to speak.
So you're saying the expert served no purpose here?
I think the expert witness did serve a purpose for the defendant to outline her story as well as to provide psychological analysis of it. And I think that was helpful to the court. But the court took the statements and essentially looked at them independently through their own lens as it related to the rest of the evidence. In Angela Vivi,
But experts do that all the time. I'm sorry, I'm missing your point here.
there is a CJI that juries are instructed with where they can accept or discredit.
Correct. But they can offer, she had the right to offer it,
She did, yes.
and the finder of fact could reject it.
Could reject it, as they did in this case. So ultimately, I don't think that the court is stuck with accepting Dr. Leswing's credibility analysis as it related to Angela in this case.
But you're
or-
not suggesting that it was inappropriate or impermissible to offer it, are you?
I would say it's not inappropriate to offer it. I'm saying if the court,
So, just to make sure, the double negatives. It was permissible, appropriate to offer it in the first instance for whatever probative value the court might take it to have.
I agree. But I would also, as a corollary to that, say if the court was deferring to the expert's credibility analysis, that would be an abuse of discretion. Absolutely.
You mean the expert's analysis of Angela Vivi, yes?
Correct. I think if we had a situation where Dr. Leswing came forward and said, I spoke with Angela Vivi for 20 hours, I found her to be credible, I found that.
Can I ask you a little bit what you mean by that? Because I think as a general matter, courts look at expert testimony and they do so to help them formulate a lens through which to analyze evidence, right? That's not just, that's perfectly acceptable, isn't it?
It is.
And so how is that distinct from what you are objecting to?
Yes. So I would compare and contrast if we're thinking about a particular type of expert. So child sexual abuse accommodation syndrome, expert testimony is permissible as to the elements that are available there. Experts in child sexual abuse accommodation syndrome cannot opine on the facts of the case themselves. What those experts do is they come before a jury or a fact finder, which can be a judge if it's a bench trial. They state what child sexual abuse accommodation syndrome is. They indicate, I have not spoken with this child, and then the finder of fact determines, number one, whether to accept child sexual abuse accommodation syndrome in general, and number two, how to apply it to the case at hand. So I think that differs from what Dr. Leswing did here. So I think domestic violence or intimate partner violence, as the amicus briefs call it, is not so far outside the ken of ordinary finders of fact that we need an expert to tell
What
us
about, putting aside the expert, what about the appellate division's statement that it's deferring to county courts' credibility determinations as they pertain to the defendant?
So my understanding there is that, and that's from the majority,
Yes.
they did not find that county courts' determination were so incredible as a matter of law that they should disregard them. So that's my understanding of that phrase.
I don't see that in the phrase. It says, "We hereby defer." I will grant you that before that, they say, given what we see in this record, we defer, but that's a term of art. We understand that, we defer.
And
Does that mean that they chose not to make their own independent credibility determination? Or is it your position they could not, that they must defer?
I think they can my position is they can make their own credibility determinations. I think the dissent was very clear in the fact that they could. But I would also say that the situation in which the appellate division can make their own credibility determinations is when the trial court made such an incredible credibility determination. So something that was so against the evidence that was presented to that court.
Thank you.
Thank you.
Thank you. Again, we're hampered by the lack of clarity in the appellate division decision, but I will say this. What sense would it make, given the remedial nature of the DVSJA, to adopt an abuse of discretion standard instead of the ordinary standard for determining legal sufficiency of the evidence and the process by which the appellate division has to go, through which the appellate division has to go when it's exercising its weight of the evidence review? It seems counterintuitive, at the least, to say that the legislature intended that in review of a DVSJA decision, the facts have to be reviewed in the light most favored to the people. It doesn't make any sense.
Do you think the appellate division here did that?
I'm sorry?
Do you think the appellate division here did that?
I think they did, and I think that was a wrong application of the legal sufficiency standard, that if the standard is you view the facts in the light most favorable to the party having the burden of proof, then the appellate division completely failed in that regard to the extent that they were making a determination based on legal sufficiency of the evidence. The appellate division, cannot make credibility determinations in a legal sufficiency review except to the extent that the evidence is incredible as a matter of law. And in this case, it's not incredible as a matter of law because it was corroborating evidence. Incredible as a matter of law, that's only when you have a witness who gives hopelessly contradictory testimony. That's not the case here. My client never wavered in saying she was an abused woman and that she felt she was acting in self-defense when she committed the offense conduct. She never wavered in that. Maybe some of the details changed, but as the dissent in the appellate division said, she was steadfast over time on those points. And even, I'm sorry? Someone asked a question?
That was a cough. You just heard someone coughing.
Sorry, I was
okay.
coughing.
As far as the credibility determinations and delegating to the psychologist, I'm not asking the court to say that the appellate division and the trial court had to delegate. All I'm asking is if they're going to reject that opinion, it has to be based on facts in the record, not on supposition, which is, I think, exactly what happened here. And as one of the judges pointed out, courts make decisions based on expert opinions all the time. It's nothing unusual about that. And I don't see what role the CJI plays, because those are instructions on law. And here we're talking about how a court evaluates facts.
Your red light is on. Thank you.
I'm sorry?
Your red light is on. Thank you.
Oh, okay. Thank you very much for your time and attention.